Good afternoon, everyone, or good morning if you're on the West Coast. This is Michele Shuster. I'm a partner at the law firm of McMurray and Shuster, and I'm very pleased to have Ben Sigall with me today to present the Intellectual Property 101 webinar, what it is, why it matters, and how to protect it. Because this is a shorter webinar, only 30 minutes, we won't take questions live, but you are welcome to submit in the chat box, and we will follow up with answers afterwards. Also, this webinar will be recorded and it's available on our website after this presentation, and you're welcome to share it with others. So with that said, I'd like to introduce Ben Sigall. Ben has been with our law firm for several years now and is our resident go-to when we have intellectual property matters. He comes about that very honestly. He was the top of his graduating class in intellectual property law and received an ABA CNA award for that. So Ben has been spending a significant amount of time in this area for many years. He's been out of law school for 13 years now. He graduated undergraduate from Ohio State University and then got his law degree from Duquesne University. And with that, if you could go to the next slide, Ben. So just a short disclaimer for all that we have with all of our webinars. We never want to provide legal advice to persons that are listening to this recording or this webinar live. It's important that you visit with your own legal counsel in order to obtain that legal advice.
So today we're going to be talking about what is intellectual property. And that's a term that doesn't refer to just one universal area, but it's really a catch-all that refers to many different types of rights and can involve distinct areas of law depending on the rights that are at issue. A good quote to use, I suppose, that indicates how broad this can be is from the World Intellectual Property Organization, which defines intellectual property as creations of the mind, such as inventions, literary and artistic works, designs, and symbols and names and images used in commerce. We like to indicate that IP law addresses the allocation of rights that are bestowed on the owner after an idea is distilled into a specific and discrete form, but that an individual doesn't have rights over the ideas themselves in their abstract form usually. Now, Michele can indicate to us why it matters so much. I think it's probably going to be evident to many of us who are on the webinar.
Yeah, definitely. So, intellectual property is so important to protect because the companies that are creating intellectual property spend a significant amount of resources and money in creating that intellectual property. And if you don't protect it, you will lose the ability to singularly use it. So really critically important that you understand what your intellectual property is and that you protect it.
Indeed, it's an asset that represents an organization's creative, intellectual, and financial investment. So as Michele said, protecting it is very often quite critical. As to how to protect it, there are four main areas of intellectual property law we're going to talk about today. The first we're going to talk about is patent law, and we're going to talk about copyright law. We're going to talk about trademark law, and we're going to talk about trade secrets. This isn't quite the entirety of IP that's out there, IP law that's out there, but it's the broadest picture that can be painted. Dealing first with patent law, you want to think inventions. That's what patents are intended to cover. We got our little guy there that is, I think, for our visual learners, kind of that image that pops into everybody's mind when they think about an invention. The guy who first invented the wheel to put on some sort of carriage or something, he would have wanted patent law at the time. He would have had an advantage if he had that protection. In order to be patented, there are three things that are required. The item has to be useful, which is usually a pretty low bar to meet. It has to be non-obvious, which is also usually a pretty low bar to meet, because if something is useful and it was obvious, someone probably would have made it before. But the tough one is usually showing that it's novel. And in order to be novel, that means it can't be something that appears in the prior art. The prior art basically means if it's been published in magazines and newspapers, in any sort of public document anywhere, that counts as being in the prior art. And if it's so heavily suggested in some document somewhere, then it can be determined to be not novel. And it doesn't matter whether you, the inventor, knew anything about this prior publication. patent examiner will do a search, and if they find in the prior art your invention, then you won't be able to meet the novel requirement. So if you think about it, what this means is that as a corollary, if you publicly disclose your own invention, you can end up preventing your own ability to get a patent because your public disclosure will have made your invention part of the prior art when you go to try and get your patent. Now, you do get somewhat of a grace period for this, so it's not as though the very moment you disclose you will have lost your ability to patent, but you can inadvertently lose your rights by making a public disclosure of your invention. So sometimes it's important to play it close to the vest, or at a very minimum, have an awareness of what that grace period is and what triggers it and when it would expire. Patent inventions break down into 4 categories. So it has to be something that's either a machine, it has to be something that's a method of doing something, or an article of a manufacturer. So think basically a product that's created, or a composition of matter. The flip of this is that in order to be patentable, i.e. an invention, it can't be something that's merely a discovery. So if you're the first to discover something that exists with or without you, you can't patent that. So something that's a law of nature, or something that's a natural physical phenomenon, or something that's an abstract idea. Those are not patentable. Now, you get kind of hairy when you deal with computer programs, because often those will implement algorithms. The algorithms themselves will not be patentable, but sometimes the process, or excuse me, the ordering of how you put the program together to implement those algorithms can be patentable. The benefit of a patent is that it confers a monopoly on the right to sell and use the invention for 20 years. Now, that 20 years can sometimes be extended. You'll hear often about drug formulations being extended if a new use is developed for that drug. You can also have slight extensions while your patent is pending, but the general rule is that you, and only you, get the right to use that invention, sell that invention for 20 years after your patent. Next, we're going to talk about copyright law. And copyright law is defined by a specific term of art here. It refers to original works of authorship that are fixed in a tangible medium of expression. And now this covers a wide universe of materials. It can include writings, movies, music, both the recordings of music as well as the performance of music, or the written version of music as well, visual artwork. We mentioned a moment ago patents for computer programs, but people will often also copyright their computer programs because they are fixed in a tangible medium of expression. The language of the computer code can and often is copyrighted as kind of a belt and suspenders to a patent if it's sought. Photographs. Now you can't you can't copyright the ability to take a photograph. So if both of us wanted to take a picture of the Eiffel Tower, we're both allowed to. But you can't copy my picture if I've copyrighted. You'll have to go take your own. And even if you, well, that speaks for itself. And you can also copyright somewhat more abstract things like fictional characters. And if they take the form maybe of industrial things like a toy, so if you think Mickey Mouse, G.I. Joe, things of that nature can have copyright. And your copyright, what you get from that is the right to exclusively reproduce the work. In other words, the right to copy it, as well as the right to make certain derivative works from it. So if you think like a sequel to a movie, and the right to perform the work if it's something like a play or a song that you've written. Technically, the moment you create the work, you have copyright in it, whether you register it or not. But it's kind of an empty right to have, because you have to register your copyright in order to be able to defend that right by bringing a lawsuit for an infringement that has occurred. So if an infringement has occurred in the past and you haven't registered yet, you won't be able to sue over that. You'll have to register and address infringements that take place thereafter. As far as the length of the copyright, there are nuances to it, and there are exceptions, and some of that has been made because of politics and some lobbying, but the general rule is that your copyright lasts for the life of the author plus 70 years. So some examples, and I think Michele might pipe in on some as relate to many of our clients, but our clients might have jingles. If you've created a commercial, you may not think of this as being all that creative, but you certainly could copyright it nonetheless. The compliance manuals, training manuals you might have created, a webinar. If you've created some authorship in connection with a flyer or marketing material that you put out, marketing scripts, or code for a phone dialer are all examples. Some issues that you might face in the copyright realm, cease and desist letters. If, for example, someone claims that you've used copyrighted music or that you've used a copyrighted image, you might get an email from an organization such as Getty Images if you pulled an image from the internet that was not approved, that's copyrighted and not approved for your commercial use. Also, it's not on the slide here, but notice and takedown demands in connection with the Digital Millennium Copyright Act are something that you might encounter, and that can involve a back and forth. If someone says to an internet service provider that you've infringed on their copyright, they may take your material down. You may then have an opportunity to reply and say, no, it shouldn't have been taken down, and that can turn into a back and forth. But if you do get a cease and desist or a takedown notice in connection with the DMCA, you may need to make an argument if you think what you're doing is fair use, because fair use is allowed. Fair use is most often if something is satire or educational in nature. But if you don't have a good defense, you may deal with the situation where you need to negotiate what the payment is going to be to address the infringing use. And you may want to have a knowledge of what the going rate for a typical infringement in the nature of what yours is, and vice versa. If you're the one who has the right that's been infringed, you may need someone to negotiate a payment to you. Next, we're going to talk about trademarks and service marks. Service marks are, for most intents and purposes, coexistent with trademarks, coterminous with trademarks. They work more or less the same way. So if I say trademark, you can just assume that it also goes for service mark in most cases. The purpose behind trademark and service mark law are twofold. First, to allow consumers to identify the source of goods or services in the marketplace so that they can do that with confidence. If they see the trademark, they know that this good comes from a certain source. And the flip side of that coin, probably more important to many clients, is to protect the goodwill and reputation that the merchant has built up in those goods and services in the marketplace. Now, if push comes to shove in the courts, there tends to be, in my experience, a little bit more concern with the rights of, or excuse me, the purpose of consumers being able to identify the source of goods with confidence and consistency. But both are purposes that can be asserted as far as, you know, a kind of a bedrock policy argument if push comes to shove in litigation. Trademarks are most often either words themselves, which we refer to as a standard character mark. So an example of one that we pulled up for this webinar was a trademark for an entity, or I guess I should say a product called Chubbos. But you can also have design marks, which are most commonly you think of as a logo. So Chubbos had both. They had both, you know, the word Chubbos, but then they also have this particular design logo with a little slice of pizza coming out of the O in that font, and you know, and so forth. Trademark protection, however, is also available for more exotic things such as distinctive packaging design, which we refer to as trade dress, and slogans if they are regularly and more or less constantly associated with the delivery of that service or the advertisement of that service or product. And even things such as scents and sounds can be trademarked in the right circumstances. Trademarks have protection under both federal and state laws, but the rights between the two are largely redundant. So what often ends up happening is the federal theories are what end up being the bulk of where the attention is paid. trademarks can exist as both registered or unregistered marks, but even though unregistered marks can bestow rights, there are lots of benefits to registration. Certain elements of a prima facie case are presumed if your mark is registered. There are more remedies available to you if your mark is registered. You establish your priority of use nationwide to help keep other people out going forward in the future if you want to expand by registering. Arguments about consumer confusion, which as we'll hear in a moment is very, very important to infringement litigation. They are bolstered if your mark is registered. You get something called incontestability after 5 years if your mark is registered. I know I've got and more listed. Another big one though is that the mere fact of having that registered mark can be a business asset, which you can assign value to. So that's not necessarily just the legal benefit, but also the business one. There are 4 different categories of marks, and they each have different legal strength. The first category is kind of like a 2-part category, which are fanciful and arbitrary marks. These are the strongest this is the strongest category of marks as far as the legal enforceability of them. Fanciful is even stronger between the two. For a fanciful mark, think of something like Kodak, which is just a made-up word that didn't mean anything before that trademark. It's not somebody's name or anything like that. It's just a made-up out of whole cloth word. So that's fanciful. And for arbitrary, a classic example would be something like Apple, at least as applied to computers, because apples don't have anything to do with computers, so it's pretty random, at least in that category. The next category of marks are suggestive marks. Now, these are considered to be strong, although not as strong as fanciful or arbitrary marks. A good example of a suggestive mark that's kind of a classic example is Microsoft. If you hear Microsoft, you might think microcomputer and software. So it kind of cleverly hints at maybe what the product is, but it's not exactly describing what it is. You don't know really, but it kind of puts that thought in your head. So a mark that kind of puts the thought in your head without actually describing or saying what the product is an example of a suggestive mark. Now, those 2 categories, fanciful and arbitrary, and then suggestive marks, are kind of in their own league. Now we're going to move on to a different league, which are descriptive marks. Now these marks start off as being weak. They can't be federally registered unless and until they achieve what's known as secondary meaning in the minds of the public, and this is also referred to as acquired distinctiveness. An example for this would be something like Yellow Pages or Lotso Chips to refer to a chocolate chip cookie product. And the reason why is this: if you think about it, Yellow Pages are literally yellow, so you're kind of describing what the product is. And Lotso Chips for a chocolate chip cookie, I should have thought a different one, say that 10 times fast, is kind of just describing, hey, these chocolate chip cookies have lots of chips. However, after time, if you can show that in the mind of the public, people think Yellow Pages means a particular source, and Lotso Chips is a particular brand of chocolate chips, and they come from one source, that it's not just describing the chocolate chip cookies, then you can show the trademark office that it's acquired distinctiveness, and you can move from what's called the supplemental register to the main register. And when you're on the main register, that's when you get the rights of being registered. And then the last category is in its own class altogether, which are generic marks. These marks cannot obtain trademark protection. Now, I used Apple again because I think it helps to highlight that it matters what the product is. So you can't trademark Apple for apples, and you also couldn't trademark fruit for apples, because those are never going to not just be generic descriptions of what the product is, rather than who is the provider of the product or its source. Trademark law historically springs from the concept of unfair competition. If your mark is unregistered and you're trying to defend it, you're most likely going to be limited to just this theory. However, if you have a registered mark, federal law also recognizes theories of trademark infringement and trademark dilution. I'm not going to dwell on dilution because that really only applies for very famous marks, but just in passing, it's the idea that people wouldn't be confused about your mark and another mark, but you kind of give the famous mark a bad reputation by your mark being similar, or you tend to blur their mark by your mark being similar. For trademark infringement, the bedrock question is going to be all about whether there's a likelihood of confusion in the minds of consumers between your registered mark and the allegedly conflicting mark, just vis-a-vis the goods or services that are being sold. And this is an area where the strength of the mark that we talked about earlier becomes very, very important. In order to obtain trademark federal registration, you have to actually use the mark in commerce in order to complete that registration. However, you can file an application based on an intent to use the mark in the future, if it's a good faith intent to use, and then perfect that registration by actually using it and filing more paperwork within 6 months. Now, we say 6 months, but you can actually get a series of extensions, so you can stretch it out substantially longer than that. But the initial intent to use application will be for a 6-month period. You have to actually put it into use. When you register, or apply to register, you have to select the classes of goods or services with respect to which the mark is going to be used or is being used. And these are broad categories. Right now, there's only 45 total, so all the things out there that can be trademarked fit within one of 45 categories. Because of that, the application must further refine itself by verbally describing the goods and services as they are going to fit within one of those 45 classes. Now, you can also register in more than 45 classes, and you might have a situation where you want to use one mark for different types of goods. For example, cookbooks are going to be one area, but aprons are going to be another. You might have the same trademark, though, that you want to use because your business has multiple legs where you're selling both cookbooks and aprons. So you may need to or want to register in both of those classes so that you'll be protected against infringement in both of the classes, because your mark registration is only going to count for the classes that you selected. The issues you need to look out for are the need to police your marks. You need to make sure that other people are infringing, because that can cause brand confusion. You can have competitors trying to piggyback from your reputation by using similar marks. There can be disputes that arise regarding the scope of someone else's licensed use of a mark that you've licensed them to use, or disputes about whether they're staying within the quality control requirements that you've laid down as part of that license. And if you don't police your marks, you can eventually lose your rights in the mark. You may find yourself having to deal with, on the other side, a cease and desist, or needing to put out a cease and desist for unauthorized use of a mark. And you need to make sure that transfers of a trademark are effective rather than destructive of that trademark. And this is something that people can gloss over, but you need to include the goodwill along with the assignment or sale of any trademark, or else it'll be ineffective and can actually undermine the mark. You also need to avoid what's known as naked licensing, which is essentially where you license someone else or multiple of someone else's to use your trademark without there being quality control measures in place. And if you do this, you can lose the right to enforce the mark through an infringement suit. So basically, you can cause your mark to become worthless by naked licensing. So it's important that you maintain the ability to dictate some degree of quality control if you're going to license your mark. Next and last, we're going to talk about trade secrets. Trade secrets are largely based on state law. Like copyright, they're very broad. They protect most information as long as you make reasonable efforts under the circumstances to keep that information secret, and that the information derives economic value from the fact that it's not generally known or readily ascertainable by a above board means, amongst others who would obtain economic value from the information. Unlike patents, the trade secret can last indefinitely, so it's not limited to 20 years. As long as the information remains a secret or secret enough and retains its economic value by virtue of it being secret enough, you can keep your trade secret. So what this means is you're kind of presented with a decision sometimes about whether you want to go the patent route or you want to go the trade secret route, because you may, if you think you can keep it secret long enough, not want it to enter the public realm after just 20 years. But vice versa, if you want to ensure no one else that you have that monopoly, whether it's kept secret or not, well, it won't be kept secret if you do a patent, but you want to ensure you have that monopoly and the 20 years is good enough, then you'd go the patent route. The classic example of a trade secret is the formula to Coca-Cola. That's still a trade secret now. It has been for forever and a day. If they had tried to patent that, assuming they would have been successful, I'm not sure off the top of my head, but if they had tried to patent that long ago, there'd be other people who were able to rip off Coca-Cola. But if someone figures out the Coca-Cola formula on their own by legitimate means, just by independently inventing it, then the trade secret owner would have no claim against that person, unlike the patent. So as I said there, yeah, if your competitor can reverse engineer the formula without cheating, they're free to do so. Really what this protection is about is to stop bad actors from misappropriating the trade secret. So no espionage, basically. But there are issues that you have to confront with trade secrets in order to maintain them. You've got to make sure that you're taking the right efforts to maintain adequate secrecy, or you could inadvertently lose your trade secret protectability. So in a conflict situation, regulators or in civil litigation, they might send you what's known as a civil investigative demand. Many of you probably know what that is, but it's similar to a subpoena. You might get an informal request from information. You might get a discovery demand. If you're involved in litigation, you might have someone who's subject to a deposition as part of litigation, or even if you're not a party to litigation, you might receive a subpoena from a third party. And in order to make sure that you don't inadvertently undermine your rights, you're going to want to be vigilant about redacting things that might be trade secrets, potentially moving to quash subpoenas if they're calling for information that are trade secrets, seeking a prophylactic protective order in connection with a disclosure of a trade secret so that it will still remain confidential enough to keep its trade secret status, having things sealed if they're going to be filed with the courts, or perhaps even seeking emergency injunctive relief to keep the cat in the bag, so to speak, if there's a trade secret that someone out there might disclose. I don't want to talk too much about our particular clients, but we had a situation like that not too long ago where we had to seek a temporary restraining order for fear that a news outlet was going to disclose some material that we thought were trade secrets, and thankfully we were successful. In the business context, in order to maintain your trade secrets, you want to help develop and establish policies for treatment of information that your employees or even officers are going to be dealing with and have in their possession. You want to have potentially confidentiality agreements in your contracts with employees, officers, and owners that address the confidentiality of trade secret material, so that, and this is also that you can show down the road that you made adequate efforts to keep it a secret so that you're entitled to the trade secret remedies. You want to have agreements in place about who owns your trade secrets, perhaps if you're dealing with a joint venture situation or any other sort of business agreement where another party might be making use of the trade secret, or perhaps as the trade secret is being invented, because these can also be things like customer price lists. I mean, it's really broad. So as things are being created, who owns them is something that you want to be vigilant about and document. Agreements that govern the treatment of and access to trade secrets and information from intercompany business ventures. Just managing all of that is important so that you don't inadvertently lose the secret nature of your trade secret as far as in the eyes of the law. So big picture wise, I think Michele was going to kind of run through some of these, but
no, go ahead, Ben. You're doing a great job. Go ahead and give the wrap up and what the takeaways are for everybody that's on the webinar, the things they need to think about after they leave us.
So we've titled this Thinking Comprehensively Now, and this really falls under the How to Protect It final leg of our presentation. And there's two main categories. One, you want to think about how to establish, secure, and protect your own intellectual property. You want to do things like considering patent registration so that you can obtain a monopoly on any useful inventions that you may have. You want to register copyright for any of your original creative works which you don't want others to potentially infringe. And this can be belt and suspenders with some of the other rights such as trademark. If you're seeking a trademark, it really behooves you to try and select a distinctive, strong trademark and register them thoroughly. And we certainly understand that sometimes there's a reason not to use a fanciful or a suggestive mark, but man, there sure is a benefit on the front end if you can pick a trademark that falls into those stronger categories. So it's worth putting that into thought process on the front end. You want to police your trademarks responsibly so that you can preserve your trademark rights, and you can even strengthen those rights by vigilantly policing. So sometimes you hear about Disney getting a bad rap, but they certainly police strong and their marks are strong. And you want to take conscious steps to identify what information you value as a trade secret so that you can have policies for all times when disclosure of trade secret information may occur, and so you can take actions that clearly demonstrate down the road, if needed, that you'd maintained high efforts to keep that secrecy. And then the other category, oh, my slide's not advancing, here we go. You want to be able to think about how to handle conflict over intellectual property responsibly. And that can mean drafting cease and desist letters that are compelling because they're thoughtful and they're on point concerning the actual relevant law and the actual violation and alleged infringement that is occurring, rather than just kind of a generic cease and desist that someone might fire out. It certainly helps when that letter really spells out, hey, this is the way it is, and it shows that you know what you're talking about. You want to analyze and then respond to cease and desist letters you receive or similar correspondence, such as the notice and takedown under the Digital Millennial Copyright Act. You want to do that carefully. And you want to be vigilant when providing information to regulators or in connection with litigation, whether you're a party to that litigation or not, especially when it comes to making sure that you're protecting trade secrets. So with that, I'll let you take over, Michele, and give the thank you for us. But I certainly thank everyone for their time.
Yeah, thank you for joining us today. And this will be available on our website in a recording form if you'd like to share it with others. And as always, if there's anything we can do to assist you with identifying, protecting, defending, or responding to an allegation of infringement of intellectual property, please don't hesitate to reach out to Ben. He'll be happy to help you with that. So have a great day, and we look forward to speaking to you all soon.
Thank you.